So let's talk about some cases. And we've got some case studies here. The first one we have is we've got a parent or spouse of an employee sues the company after the employee took his or her own life. And I wanted to talk about a case that came out of federal court in California called Janelle Jones versus Matthew Cate. The widow of Janelle Jones is the widow. Scott Jones is her late husband. She sued after he took his life, having worked as a corrections officer for the California Department of Correction and Rehabilitation. And the case is important because it illustrates examples where in a suicide, there is potential liability for the employer and managers and supervisors. And what that court held was the employer or supervisor can be liable for one, their own culpable actions or inaction in the training, supervision, or control of subordinates. Two, their acquiescence in the constitutional deprivation of which a complaint is made. Or three, the conduct that showed a reckless or callous indifference to the rights of others. In that case, there was also a component of retaliation. And the court found the case can go forward on retaliation, because in this situation, the plaintiff had alleged a complaint was made, that the employer was aware of the complaint, that bad things happened to the employee who complained within, number four, close temporal proximity. So that R word, retaliation, be very careful you don't run into a situation where an employee who is going through problems complains and then things get worse. And it also, this case teaches us that if you've got an effective program in place, that you train your employees on the program, you disseminate materials on that program, that becomes a very, very good defense. Okay, now it also shows that harassment, hostile work environment, disparate treatment can be the underlying claim under discrimination laws and not workers' comp for employees who fall into that purview of having a medical condition or anxiety or stress and end up attempting suicide. Now, what about an EAP? Does that help? And the answer is absolutely. The Supreme Court about 22, 23 years ago created something called the Farragher defense, and that is that an effective anti-harassment policy, training, dissemination of a policy are things employers can do. You take an EAP and you add an EAP to that, and it's a good program. Number one, you're going to eliminate some of the instances because people will get help, and two, you eliminate risk. So a good training program, and we're going to talk about training in a few minutes, as opposed to a poor training program, is also a critical factor. So let's talk about the second example. And this is an example where the employee requested but was denied an accommodation and attempted suicide. This is, I'm going to talk about a case that was one I handled. There's a company in New York, and this is going back several years. And they were going through a period of rapid growth, and they were bringing in a lot of employees, and a lot of people either were hired at or promoted up into supervisory positions, and none of them had training. They were all on a gerbil wheel, rushing every single day, rushing, trying to keep up with their work. And the supervisors were under a huge amount of pressure to keep up and deliver on time. So one of the employees started to feel anxiety, started to feel stress, and the employee goes over to the manager and says, I need a breather. Either have me cut down to half days or 2 or 3 days a week for a period of a month. Let me slow down and catch my breath. And the manager says, no, you can't do it. All hands on deck. We've got to get the project done. The pressure continued to build, and the employee exploded. Attempted suicide and brought the lawsuit. Now, in that situation, what the employer should have done is the supervisor should have gone to HR or to the company's legal department and said, here's what's going on, what's the proper response. The supervisor did not do it, just simply denied the request. this was a prima facie case. It was a case that either it was going to get settled or it's going to go to a trier of fact. We wound up settling the case. And that illustrates another example of where there is exposure, where there is risk to an employer. But let's flip it a little bit. What if the employee in the case, having attempted suicide, wants to come back to work? How do we reintegrate that person into society?